There are moments when the American legal system stops drifting and begins to press forward, quietly, methodically, without drama. These moments are often missed because they lack spectacle, but they matter more than most of what fills the news cycle. They are when law stops being theory and becomes force. This is one of those moments. For years, the question surrounding the Jeffrey Epstein case has not been whether crimes occurred. That question was settled long ago. The question has been institutional. Who knew? Who protected whom? And why the state, with all its tools, appeared unwilling to expose the full record. Congress attempted to answer that question with legislation, not with rhetoric, not with hearings, with law. The Epstein Files Transparency Act was not ambiguous. It was not aspirational. It was a mandate, passed by a bipartisan Congress, signed by the President, directed at one institution, the Department of Justice. The instruction was plain. Disclose the records. All of them. With narrow and explicit limits. No discretionary delays. No reputational shielding. No political sensitivity exceptions. And yet, here we are. In a filing released with little fanfare and less explanation, the Department of Justice acknowledged that it has released less than 1% of the records in its possession. Less than 1%. After the statutory deadline, after public assurances, after decades of delay, that admission alone would be enough to raise concern. But the filing went further. It asserted legal privileges that Congress had explicitly stripped away. It claimed authority to withhold records based on doctrines the statute was designed to nullify. This is not foot-dragging. It is defiance. The department is not asking for time. It is asserting power. It is saying, in effect, that it will decide which laws constrain it and which do not. That is not a technical dispute. It is a constitutional one. The Transparency Act emerged from an unusual alliance. Lawmakers with little else in common agreed that the Epstein case represented a failure of institutions, not a single failure, a layered one. Prosecutorial discretion, regulatory capture, deference to status, fear of consequence. The statute was drafted to remove excuses. It did not permit withholding based on embarrassment. It did not allow redaction to spare reputations. It did not permit delay based on administrative burden. Congress understood how bureaucracies work. It wrote accordingly. The law gave the department 30 days. That was intentional. Bureaucracies excel at delay. Congress denied them that refuge. The deadline passed. What followed was silence, then a small release of documents already known, public court records, material that had been litigated and discussed for years. The substantive files remained sealed. Then came the letter. On January 6th, the Deputy Attorney General informed Congress and the court that the department had discovered millions of additional documents requiring review. Millions. After decades of investigation, after prior assurances of review and closure. This is not an explanation. It is a confession of either incompetence or misdirection. If the documents existed all along, then prior representations were false. If they did not, then their sudden appearance raises its own questions. Either way, the department's credibility suffers. But volume is not the core issue. The law anticipated volume. That is why it limited grounds for withholding. That is why it required an index of non-disclosure, a catalog of what was withheld and why. The department provided no such index. It missed the deadline, it missed the disclosure, and it missed the accountability mechanism built into the statute. That absence is not procedural, it is strategic. Without an index, there is no way to challenge redactions, no way to test claims, no way to know what is being hidden. Darkness is not a byproduct here, it is the condition. The department's primary justification is privacy, specifically the privacy of victims and of unindicted third parties. The first is legitimate. The second is the problem. Victim privacy has long been a shield in this case. Properly applied, it protects those harmed. Improperly applied, it protects those who did harm or enabled it. The statute allowed redaction of victim identifiers, names, addresses, personal data. That is uncontroversial, but the department has extended this logic to unindicted third parties. In plain terms, individuals mentioned in files who were never charged. In ordinary cases, that category exists to prevent reputational harm to innocent people. In the Epstein case, it encompasses the most powerful people connected to him. This is precisely the category Congress intended to expose. The statute explicitly barred withholding based on reputational harm. It anticipated this argument. It rejected it. Yet the department now asserts that it can redact names because those individuals were never charged. That is not compliance, it is nullification. If the government declines to charge someone and then cites the absence of charges as a reason to conceal their involvement, the logic becomes circular. Prosecutorial discretion becomes a permanent cloak. This is not theoretical, it is the central issue. The Epstein case is not about whether crimes occurred. It is about why prosecutions were limited, deferred, or abandoned. Internal communications, interview summaries, surveillance records. These documents answer that question. The department's refusal to release them preserves ambiguity. Ambiguity favors power. This posture becomes more troubling when viewed alongside the department's conduct in late December. For a brief period, new documents appeared on a public portal. Among them were flight logs and photographs. One image appeared to show Donald Trump aboard Epstein's aircraft. This was not new information. Trump has acknowledged flying on the plane, but an official image carries different weight. It is evidence. It is institutional confirmation. Within hours, the file disappeared. The department explained that materials were being reviewed and redacted out of an abundance of caution. That phrase appears often in government statements. It rarely means what it says. Caution is understandable before release. It is less defensible after publication. Once a record is lawfully disclosed under a transparency statute, retracting it because it causes discomfort raises serious legal questions. The statute forbids withholding based on political sensitivity. Retracting a document because it implicates the sitting president looks precisely like that. The department compounded the issue by issuing a public disclaimer suggesting that some materials in the release contained false claims submitted before the 2020 election. This is extraordinary. The custodian of records was preemptively discrediting its own files. That is not neutral administration. It is advocacy. The department is not required to vouch for the truth of every document in its possession. It is required to release them. Context can follow. Suppression cannot. By selectively scrubbing and selectively warning, the department undermines confidence in the entire process. It invites speculation while claiming to prevent it. This is how institutions lose trust. The scale of the delay defies explanation. Millions of documents, duplicate files, technical challenges. These claims might carry weight in another era. They do not in 2026. The federal government processes vast datasets routinely: surveillance, financial records, communications. It does so quickly when enforcement demands it. When delay appears only in cases involving powerful interests, explanations ring hollow. Lawmakers have noticed. Members of Congress from opposing parties have accused the department of asserting privileges not permitted by law: common law privileges, deliberative process, internal communications. These doctrines exist to protect honest governance. They do not exist to override statutes. Congress can remove them. It did. The department's position is not that the statute is unclear. It is that the statute is inconvenient. That is not how constitutional government works. The executive branch does not get to choose which laws it will honor based on preference or pressure. When it does, separation of powers erodes. This is where the question of motive arises. Attorney General Pam Bondi is not an institutional neutral. She is a political appointee with long-standing ties to the president. The Deputy Attorney General, Todd Blanche, previously served as Trump's personal defense attorney. This is not disqualifying per se, but it is relevant. When decisions about disclosure involve documents that may implicate the president, conflicts of interest are not hypothetical. They are structural. The Transparency Act was designed to remove discretion from precisely these officials, to make disclosure mandatory, to bypass judgment calls. The department's resistance suggests that discretion has been reclaimed. Why? One explanation is institutional self-preservation. The Epstein case implicates failures across administrations, prosecutors, agents, regulators. Disclosure may expose not just individuals, but systems. Another explanation is political protection. The files may implicate figures across parties. Exposure would destabilize alliances, damage reputations, alter narratives. A third explanation is national security. The department may believe that disclosure could affect foreign relations, compromise intelligence, reveal leverage. The statute anticipated this too. It provided a mechanism for classified material, a process, not a veto. The department has not followed that process. Instead, it has defaulted to refusal. This is not how transparent governance functions. It is how secrecy perpetuates itself. The question now is not whether the department can delay, it is whether it can be compelled. Members of Congress have asked a federal judge to appoint a special master, an independent authority to take custody of the files and enforce the statute. This is a significant step. It signals a breakdown of trust between branches. If granted, it would remove control from the department. It would impose the law as written. The department opposes this. It argues the court lacks jurisdiction, that the case is closed, that oversight deadlines are not enforceable in this context. These are technical arguments. They may succeed. Courts are often reluctant to intervene in interbranch disputes, but the optics are unmistakable. A law exists, a deadline passed, a mandate ignored, and the enforcing institution resists oversight. That pattern has consequences. Trust in institutions is not maintained by assurances. It is maintained by compliance. The Epstein case has become a test not of morality, but of governance, of whether the law applies evenly, of whether transparency statutes have teeth, of whether power yields to rule. So far, the answer is uncertain, and uncertainty favors those with the most to lose from clarity. The deeper issue is not delay. Delay is familiar. Delay is the default posture of large institutions. The deeper issue is precedent. If the Department of Justice can openly disregard a disclosure mandate passed by Congress and signed by the President, then transparency laws become advisory. They exist for display, not enforcement. That is not a small matter. It reshapes the balance between branches. Congress writes laws. The executive executes them. When the executive decides which laws it will execute fully and which it will reinterpret out of existence, the constitutional order shifts. The Epstein Files Transparency Act was not vague. It was not a symbolic gesture. It was an attempt to force a reckoning with institutional failure. The department's response suggests the reckoning is unwelcome. Consider the argument advanced by the department's lawyers. They claim the court lacks jurisdiction to enforce a congressional deadline related to a closed criminal case. This is a narrow reading. It treats the statute as an internal management suggestion rather than a binding command. But Congress did not write the law as a suggestion. It imposed duties. It removed discretion. It anticipated resistance. The department's argument is essentially that once prosecutors decide not to pursue charges, all related records become insulated from legislative oversight. That would be an extraordinary expansion of executive power. It would mean that the decision not to prosecute is also a decision to bury history. That logic would apply far beyond Epstein. Any case involving powerful interests could be closed quietly, after which oversight would be deemed improper. The incentive structure is obvious. This is why Congress included language stripping away common law privileges. It knew the department would reach for them. It closed that door. The department is now attempting to reopen it. The question of motive inevitably arises, but motive is less important than effect. The effect is obstruction. The refusal to produce an index of withheld documents is particularly telling. Transparency laws rely on indexes. They allow courts and lawmakers to assess claims of privilege. Without an index, review is impossible. This is not a bureaucratic oversight. It is a strategy. Without an index, there is no way to know whether withheld documents concern victims, perpetrators, prosecutors, or politicians. All are treated as the same. All disappear behind the same curtain. The department insists it is protecting victims. That claim deserves scrutiny. Protecting victims does not require protecting associates. It does not require protecting decision makers. It does not require protecting failures. Victims have waited decades for the truth. Withholding records delays that truth. It does not protect it. The irony is that the longer the department delays, the more speculation fills the vacuum. Silence invites conjecture. Partial disclosure fuels distrust. Transparency is not destabilizing. Secrecy is. There is a temptation to frame this as a partisan issue. It is not. The Epstein case crosses administrations. It implicates prosecutors appointed by both parties. It implicates regulators. It implicates institutions that prefer discretion to accountability. That is why the bipartisan support for the Transparency Act mattered. It was an attempt to rise above partisan incentives. The department's resistance undermines that effort. It also undermines the president's own stated position. Donald Trump campaigned on the promise of disclosure. He encouraged passage of the act. He signed it publicly. Yet his administration is now the vehicle for its frustration. This contradiction invites inference. Either the president underestimated the consequences of disclosure, or he assumed control of the process would allow for management of outcomes. In either case, the result is the same. The law exists. The records remain hidden. The presence of former defense counsel in senior Justice Department roles intensifies scrutiny. The issue is not personal integrity, it is institutional design. Conflicts of interest do not require bad faith, they require incentives. When the same individuals responsible for defending a client are later responsible for releasing records that may implicate that client, skepticism is rational. This is why the statute removed discretion. This is why Congress wrote in mandates rather than standards. The department's assertion of discretion is therefore a rejection of legislative intent. The request for a special master reflects this breakdown. It is an extraordinary remedy. Courts do not grant it lightly. But extraordinary remedies exist for extraordinary circumstances. If a court determines that the department cannot be trusted to comply with the law, it may intervene. That would mark a significant moment. It would signal that transparency statutes are enforceable, that executive resistance has limits. It would also provoke institutional backlash. The department will argue separation of powers. It will argue executive authority. It will argue national security. Courts are cautious in such disputes. They prefer compromise to confrontation. But compromise requires good faith. And good faith requires compliance with deadlines, production of indexes, and adherence to statutory limits. None of those conditions has been met. The national security argument looms in the background. It is the ultimate shield. The claim that disclosure could destabilize alliances or expose foreign leaders. The statute anticipated this as well. It allowed classification where appropriate. It required process. It did not allow blanket refusal. National security cannot be a synonym for institutional embarrassment. If foreign leaders are implicated in crimes, that is not a reason for secrecy. It is a reason for diplomacy informed by truth. The danger is not exposure. It is blackmail. It is leverage. It is the existence of secrets that can be exploited. Transparency reduces that risk. Secrecy amplifies it. The Epstein case is often discussed in moral terms. It should also be discussed in structural ones. It reveals how systems protect themselves, how discretion accumulates, how oversight erodes. It reveals the limits of outrage and the power of process. For years, outrage flared. Little changed. Now, process has been invoked, and the system resists. That resistance is instructive. It suggests that the real scandal is not confined to one individual. It is distributed across institutions. The refusal to release records is not an admission of guilt. It is an admission of fear. Fear of consequence, fear of exposure, fear of precedent. If these records are released, demands will follow. For accountability, for reform, for explanation. Institutions prefer closure. Disclosure reopens cases. It invites scrutiny. This is why transparency laws exist, to force institutions to confront their own history. The Epstein Files Transparency Act was an attempt to do that. It remains unfulfilled. The coming months will determine whether it remains unenforced. If the court declines to intervene, the department's position will harden. Delay will become denial. Time will do the rest. If the court intervenes, the executive will protest. Appeals will follow. Delay will continue. In either scenario, the truth will not emerge quickly, but the principle matters. If the department succeeds in nullifying the statute through resistance, future transparency efforts will be weakened. Agencies will learn that mandates can be ignored. Deadlines can be missed. Privileges can be asserted regardless of legislative intent. That lesson will not be limited to this case. The Epstein case has become a proxy for something larger. The question of whether institutions can police themselves, or whether they require external compulsion. History suggests the latter. The founders designed a system of ambition counteracting ambition. They did not assume virtue. They assumed incentives. Transparency statutes are modern expressions of that logic. They assume resistance. They anticipate evasion. They attempt to constrain both. When those constraints fail, the system falters. The Department of Justice is not a villain. It is an institution. Like all institutions, it responds to incentives. It protects prerogatives. It resists intrusion. That does not make it malicious. It makes it human. The remedy is not outrage. It is enforcement. The question now is whether enforcement will occur. Congress has acted, the law exists, the executive resists, the judiciary hesitates. This is the constitutional drama, not a conspiracy, not a spectacle, a test of process. If the law is enforced, the records will emerge. They will be messy. They will be incomplete. They will implicate some and exonerate others. They will not provide closure, but they will provide truth. If the law is not enforced, the lesson will be clear. Transparency is conditional. Power decides. That lesson will endure long after this case fades. The Epstein case will eventually recede from headlines. The documents may never fully emerge. The moment will pass. What will remain is the precedent. Whether Congress can compel disclosure, whether the executive must comply, whether the courts will intervene. Those questions define governance more than any individual scandal. The public has limited power in this process, but it has some. Attention matters. Persistence matters. Demand matters. Transparency does not arrive because institutions volunteer it. It arrives because it is insisted upon. This case is not about curiosity. It is about accountability. It is not about vengeance. It is about record. It is not about scandal. It is about law. What happens next will say much about the durability of American institutions and about their willingness to confront themselves. If you have thoughts on whether the Department of Justice should be compelled to release these records, or on what transparency should mean when powerful interests are involved, share your perspective. Join the discussion and subscribe for continued analysis as this story develops.